Hi, welcome again to Business Immigration Online. This is another presentation about the basics of the permanent employment-based immigration. I want to discuss several aspects of the relationship between immigrants and non-immigrant in the context of employment. Basic concept, as we said, the most important thing distinguishing an immigrant from a non-immigrant is intent. And in this context, intent has two manifestations. One in the non-immigrant versus immigrant. As we saw, for most non-immigrant visas, there has to be some non-immigrant intent, sometime not very strong, but in some cases very strong, that includes home residence and includes home ties and so on. Um, in order to evidence the intent to depart the United States once the purpose of the stay here is accomplished. Immigrants don't have to show that kind of intent. As we said, the law actually presumes that anyone who wants to come to this country intends to immigrate here permanently, shifting the burden to the person to prove if they are non-immigrants. Um, there is another manifestation for intent in this context of permanent immigration, because in order to get a green card in most of the categories that we're going to discuss, the foreign national must have the intent to be employed by the petitioning employer permanently, and the employer must have the intent to employ the person permanently. Now, permanently doesn't mean forever, but permanently means for the foreseeable future. Now, as we discussed, intent, of course, is subjective, and immigration doesn't really know yet how to read mind. So the intent can be inferred in many situations from objective actions and circumstances. So if there is an employment-based green card application, and it's based on the fact that the employer and the employee both want to work and be employed once the green card arrives. Then, if the employee, the day after they receive the green card, disappears, this is a pretty strong manifestation that there was no intent there. If they leave after 5 years, that's something else, or after a year. But if they uh, manifest no intent to actually work for the employer, or if the employer, once the person gets the green card, tells them, go away, I don't want to see you, that is, again, might be inferred as non bona fide intent to employ or be employed. So, like in the non-immigrant intent, when you have to show that a person has home ties and intend to leave the United States, the same goes um, for the immigrant part. There are, as we're going to see, quite a few similarities between certain categories of non-immigrants and certain EB classification in terms of the requirement. Um, these similarities are not identical in many cases, so you have to be aware exactly where you are. In some situation, it is identical, but in most, it's not exactly the same, and the differences might be critical. And even when the requirements are similar or even identical, um, the scrutiny is usually much higher in the EB, in the permanent context, as opposed to a non-immigrant. Uh, this is not written in any law, but as a matter of fact, because it's perceived to be a higher level of benefit, a green card as opposed to a visa, USCIS tend to scrutinize application more critically. And you should also remember that in general, it's not the same offices within USCIS that review immigrant application and non-immigrant application. So you should not assume that if a non-immigrant visa was approved, a similarly um, um, filed an immigrant petition will be approved and vice versa. Um, So that's important to remember. First of all, make sure what is the same and what is not. And secondly, remember that there is no necessarily relation between approval of non-immigrant and immigrant. Now, what are the interrelations between the EB process, the permanent immigration process, and the non-immigrant process? Um, in general, in the US, non-immigrant visa is not a pass for a green card. What does that mean? It means that you don't need to have a non-immigrant visa in order to get a green card based on employment. And even if you have a visa for 50 years, doesn't necessarily mean that you're any closer to a green card. It's someone who never had a non-immigrant visa and now will get a green card. So the two things run on different planes. Um, and in order to get a green card, a person could never have a non-immigrant visa. The person may have never set foot in the United States for all intent and purposes. The EB process, until its very end, is a future looking process. It's prospective. It basically says, I intend to hire the employee, and the employee intend to work for the employer once the person receives their immigrant visa or green card. So that's important to remember. So it's not something that can be automatically um, assumed that if a person has a certain non-immigrant status, they will get a certain kind of employment-based process. That is not necessarily the case. Um, Usually, the employment base and the non-immigrant run in their own path and don't really intersect. Um, Meaning that the EB does not give any benefits for NIV status, and the NIV does not give any benefit to the employment base. The exceptions that we saw is in AC 21, when a person can extend H1B when there are um, when there is a certain green card process on the way. So here there is definitely a connection made between the two processes. We also saw it in the J1 home residency requirement that if a person held certain type of J1s, they might not be able to get a green card until they meet those requirements of home residency or get a waiver. We also, a recent one we saw is the um, ability of spouses of H1B in H4 to be employed once there is an I-140 approved, or the H1B has been extended based on AC21. Um, Now, remember that for NIV, the categories are not in any particular hierarchy. There is no generally one visa that is higher than another visa as such. In the employment base, the categories are organized in hierarchy, meaning that in general, the higher the priority or the preference, the shorter the wait time, the quicker the processes, and often in the higher categories, you also skip some some processes, mainly the labor certification application, which is a major issue in the employment-based context, and we're going to see it in one of the coming presentations. So remember that the relationship are not always clear and not always affect each other, and the jump from one to the other should be done carefully when you look in a little more details.